Imagine a courtroom today, packed not with a mere 12 jurors, but with 501. 501 ordinary citizens, their hands poised, ready to cast a vote that would decide the fate of an individual or even the very future of their city. This wasn't a rare spectacle in ancient Athens. It was the astonishing, everyday reality of their justice system. In the bustling, vibrant heart of the world's first radical democracy, where citizens didn't merely elect representatives, but held direct, personal power over lawmaking and governance, the administration of justice was elevated to an unprecedented scale. But why? Why? In a city renowned for its philosophers, its playwrights, and its breathtaking architectural innovations, did they entrust such immense power to such a colossal jury? Why 501, or sometimes even 1001, or 1501, for what we might consider a routine court case? This profound and often baffling question lies at the core of our journey. What were the deep philosophical, pragmatic, and social motivations that drove the Athenians to construct a judicial system so utterly unlike any other in history, and indeed, so strikingly different from our own? Join us as we step back 2.5 millennia into the sun-drenched agora and the echoing, sacred halls of the Heliaea. We will unravel the intricate mechanisms of this extraordinary system, exploring how it served as a radical bulwark against corruption and tyranny, a rigorous school for civic duty, and a direct, uncompromising manifestation of the demos' sovereignty. From the philosophical underpinnings laid by visionary lawmakers like Solon and Cleisthenes to the daily realities of citizens casting their bronze ballots, we will peel back the layers of a truly revolutionary experiment in popular justice. Prepare to discover the power of 501. Imagine a world where democracy wasn't a distant ideal, but a living, breathing entity forged in the crucible of a bustling city-state. We transport ourselves to ancient Athens, 5th century BCE, a vibrant metropolis pulsating with innovation, philosophy, and an unprecedented political experiment. Here, amidst the sun-drenched marble and the lively clamor of the agora, the very concept of rule by the people was being painstakingly etched into civilization's bedrock. This was a society pushing the boundaries of governance, where citizens, not kings or tyrants, held the reins of power. It was a radical departure, a bold vision that would forever alter the course of human history, laying the foundational stones for the democratic principles we grapple with even today. But how did such an audacious system truly take shape? And what were its most astonishing manifestations? In Athens, democracy wasn't merely a word. It was a way of life, a constant, active participation by its citizenry. Unlike modern representative democracies, Athenians practiced direct rule. Every major decision, from declarations of war to the construction of public works, was debated and voted upon by thousands of eligible citizens gathered on the Nix, the city's Assembly Hill. This wasn't a system of elected officials acting on behalf of the people. It was the people themselves directly steering the ship of state. This profound commitment to direct popular sovereignty permeated every facet of civic existence, ensuring that ultimate power resided not in a select few, but in the collective will of its free male citizens. It was within this unique, intensely participatory framework that their judicial system, with its truly colossal juries, would find its astonishing form. Before the age of these grand citizen juries, justice in Athens bore little resemblance to the widespread participation that would define its later era. For centuries, the dispensation of law was often the prerogative of aristocratic elites, powerful families whose social standing and wealth afforded them influence, or individual magistrates acting with considerable autonomy. Decisions were often opaque, justice subjective, and accountability limited. The very notion of ordinary citizens holding the power of judgment was a distant dream. But as Athens evolved from an oligarchy toward a more inclusive political structure, so too did its judicial philosophy. The growing demand for fairness, transparency, and popular control began to chip away at the old order, paving the way for a revolutionary transformation in how justice was not just administered, but embodied by the very people it served. The pivotal shift towards truly popular justice began with the transformative reforms of Cleisthenes around 508/507 BCE. Often hailed as the father of Athenian democracy, Cleisthenes dismantled the old tribal divisions based on kinship and regional power, replacing them with 10 new, geographically diverse tribes, or phylli. This ingenious restructuring was designed to break the power of aristocratic factions and foster a new sense of civic unity, where loyalty was to the polis, not family. Crucially, these reforms laid the essential groundwork for the dikasteria, the citizen-run law courts. By creating a more unified and participatory citizenry, Cleisthenes inadvertently prepared the Athenian people for an unprecedented role, that of judge and jury, a foundation upon which the future colossal juries would stand. While Cleisthenes provided the blueprint, it was the radical reforms enacted under Ephialtes and later solidified by Pericles in the mid-5th century BCE that truly unleashed the power of the citizen jury. These leaders boldly challenged the enduring authority of the venerable Areopagus Council, a body composed of former archons, who for generations had held immense judicial and political power. Ephialtes systematically stripped the Areopagus of its extensive powers, transferring them directly to the people's courts, the dikasteria. Pericles then cemented these reforms, famously introducing pay for jury service, a crucial measure that ensured even the poorest citizens could afford to participate. This wasn't just a political reshuffling. It was a profound act of empowerment, democratizing justice and making every citizen a potential guardian of the law, forever altering the balance of power in Athens. With the reforms fully in place, the question remained, who were these extraordinary citizen judges? In ancient Athens, the privilege and duty of jury service, like all civic participation, was exclusively reserved for free adult male citizens, aged 30 or older. Women, enslaved people, and foreign residents, though vital to Athenian society, were excluded from this defining aspect of public life. For eligible men, however, jury duty was not an option, but a sacred civic responsibility, a direct expression of their sovereignty. These weren't legal professionals or a select few, but ordinary Athenians, farmers, merchants, craftsmen, philosophers, drawn from every walk of life. Their collective wisdom, their sense of justice, and their intimate understanding of their community formed the very bedrock of Athenian law, making the dikasteria a truly popular court. To safeguard the integrity of their colossal juries and to prevent corruption, Athens engineered a device of astounding ingenuity, the clariterion. This stone slab, riddled with slots and tubes, was the ultimate anti-corruption mechanism. Each eligible citizen had a personal identification tablet, or pinakion, which was inserted into a specific slot. Marbles, colored black and white, were then released down a tube, determining who would serve. A white marble meant selection, a black one meant rejection. This intricate system ensured that jury selection was entirely random, making it virtually impossible for powerful individuals to bribe or influence the composition of a jury. The clariterion was a testament to Athenian foresight, a brilliant blend of mechanical engineering and democratic principle, designed to protect the very essence of fair justice. Every morning, the heart of Athenian justice began with a dramatic daily ritual. Thousands of eligible citizens would gather before dawn in the agora, their pinakion tablets in hand, eager to participate in the day's proceedings. The air would hum with anticipation as the clariteria were brought out. Not just one jury, but multiple juries were selected for various courts, often simultaneously. The sheer scale of this operation was staggering, a logistical marvel orchestrated daily. This meticulous, randomized lottery ensured that no one, not even the presiding magistrates, knew which citizens would serve on which jury until the last possible moment. This impenetrable veil of anonymity was the ultimate guardian against bias and manipulation, a testament to Athens' unwavering commitment to a truly impartial and people-driven system of justice, where 501 ordinary citizens could hold the fate of another in their hands. But how did Athens ensure that this monumental system wasn't just a playground for the wealthy? The answer lies in a revolutionary reform introduced by the visionary statesman Pericles around 450 BCE. He understood that true democracy demanded participation from all citizens, not just those with ample leisure and means. Pericles enacted a radical policy, a small payment, an obol, for serving on jury. This seemingly minor coin was a seismic shift, empowering poorer citizens, farmers, and artisans to leave their work for a day and contribute directly to the city's justice system. It transformed jury duty from an elite pastime into an accessible civic right, ensuring that the colossal juries truly represented the diverse socio-economic fabric of Athens. This simple payment underscored Athens' profound commitment to an inclusive, participatory democracy, laying the groundwork for the unique scale of its judicial proceedings. So, with a mechanism for broad participation in place, we return to our central, perplexing question. Why 501 jurors? It's a number that feels both arbitrary and incredibly specific. Why not 100? Why not 1,000? This wasn't a whimsical choice. It was a deliberate, sophisticated strategy born from a profound understanding of human nature, power dynamics, and the very spirit of Athenian democracy. This seemingly magic number of 501 for typical cases, and even larger panels for trials of immense gravity, wasn't just about ensuring justice. It was about protecting the delicate balance of power within their radical direct democracy. As we peel back the layers, we'll discover ingenious practicalities, philosophical principles, and a deep-seated suspicion of concentrated power that shaped Athens' extraordinary legal system. One of the most potent reasons for assembling such a massive jury was remarkably pragmatic, to make bribery and corruption exceptionally difficult, if not impossible. In any legal system, the potential for manipulation looms large. A small jury, say of 12 individuals, presents a far more manageable target for those seeking to illicitly influence an outcome. The cost, logistics, and inherent risks of attempting to sway a mere handful of people are relatively low. But consider the monumental task of corrupting 501 independent citizens, each with their own conscience and watchful neighbors. The sheer expense, the number of intermediaries required, and the almost guaranteed exposure made such an endeavor practically unfeasible. The immense jury size served as a powerful, built-in deterrent, safeguarding the integrity of the judicial process against the insidious creep of financial influence. Beyond preventing outright corruption, the colossal jury size served another crucial function. It dramatically diluted the power of individual influence and personal bias. In a smaller panel, a single charismatic juror, or one with a strong personal connection to either the plaintiff or defendant, could disproportionately sway the outcome. Prejudices, personal vendettas, or even simple friendships could subtly warp justice. But when confronted with 501 diverse opinions, any singular bias becomes just one voice in a vast chorus. It forced decisions to be based on a broader consensus, compelling jurors to move beyond personal inclinations and towards what they believed was the collective good. The wisdom of the crowd, in this sense, aimed to transcend individual frailties, striving for a more objective and impartial form of justice. Serving on one of these enormous juries was far more than a duty. It was a profound form of civic education, a masterclass in direct democracy. Imagine hundreds of ordinary citizens, farmers, merchants, craftsmen, sitting side by side, listening intently to legal arguments, scrutinizing evidence, and debating points of law. This direct engagement was considered vital for fostering an informed and committed citizenry. It brought the abstract principles of justice and law into tangible, practical application, teaching citizens not just what the laws were, but why they mattered and how they impacted society. Every trial was a living classroom, solidifying understanding of the Athenian constitution, promoting critical thinking and strengthening the bonds of shared governance. It was democracy in action on a scale rarely seen before or since. In a society that valued rhetoric, the large jury also served as a crucial check on the power of demagogues and overly manipulative speakers. While eloquent persuasion was highly prized, addressing 501 jurors meant speakers couldn't rely on cheap tricks or narrow appeals. A smaller, less diverse group might be more susceptible to emotional histrionics or partisan arguments. But a vast, heterogeneous jury, representing a broad cross-section of Athenian society, demanded arguments rooted in logic, evidence, and appeals to the common good. Speakers were forced to be truly persuasive, articulate, and able to address a wide spectrum of opinions, rather than simply exploiting the biases of a select few. The sheer scale of the jury thus acted as a filter, favoring genuine oratory and sound reasoning over manipulative rhetorical overkill. Perhaps the most profound philosophical reason behind the immense jury was its symbolic and practical role as a direct representation of the demos, the people themselves. In a radical direct democracy, the collective will of the citizens was paramount. A jury of 501 wasn't just a legal panel. It was a living, breathing microcosm of the entire Athenian citizenry. When a verdict was rendered, it wasn't merely the decision of a few appointed judges, but the voice of the people, expressing their collective values, ethical standards, and understanding of justice. This ensured that legal outcomes truly reflected the moral compass of the city, making every trial a direct reaffirmation of democratic sovereignty. The 501 jurors embodied the ultimate authority in Athens, bridging the gap between state and citizen in the most visceral way possible. Finally, beyond the grand philosophical and practical reasons, there was a simple, ingenious mathematical principle at play in the choice of 501 jurors, the odd number. Athenian trials demanded a definitive outcome. There could be no hung juries or tied votes. By always constituting their juries with an odd number of members, be it 501 for typical cases, 201 for lesser offenses, or even 1001 or 1501 for more significant trials, they guaranteed a clear majority or minority verdict. It was an elegant, almost deceptively simple solution to a fundamental procedural challenge. This practical consideration underscored the Athenians' meticulous approach to their legal system, ensuring efficiency and finality in every judgment. The power of 501, then, was a testament not just to their democratic ideals, but also to their remarkable ingenuity in execution. As the sun climbed over the Acropolis, casting long shadows across the Pnyx, the heartbeat of Athenian justice began its rhythm. The colossal court juries we speak of were not random gatherings, but carefully selected members of the dikasteria, often collectively known as the Helai. This wasn't merely a court. It was Athens' supreme judicial body, a grand assembly of 6,000 sworn citizens, drawn annually from every tribe, who stood ready to serve their city. Imagine a pool of thousands, all eligible to pass judgment on their peers. This immense citizen body wasn't just a symbol of radical democracy. It was its very engine, ensuring that justice, for better or worse, always remained firmly in the hands of the people, a testament to Athens' unwavering commitment to direct participation. Step inside an Athenian courtroom, and you'd find yourself transported to a scene far removed from our quiet, hushed halls of justice. This was no solemn chamber. It was a vibrant, often raucous public spectacle. Imagine hundreds of jurors, the 501, sitting on wooden benches exposed to the elements, their faces reflecting the harsh Athenian sun. The air would have been thick with anticipation, the buzz of conversation, and the impassioned cries of litigants. Here, citizens weren't just observers. They were the very embodiment of the law, judge, jury, and often even executioner. They actively participated, reacting audibly to arguments, their collective mood swaying the fate of the accused, turning every trial into a high-stakes dramatic performance played out on a grand public stage. Crucially, in this radical system, there were no professional lawyers, as we understand them today. Accusers and defendants, rich or poor, famous or obscure, had to present their own cases, to speak for themselves before this formidable assembly of 501. This demanded not just a grasp of the law, but potent rhetorical skill, the ability to persuade, to move a jury with words alone. For those less articulate, a unique profession emerged, the logographer or speechwriter. These skilled individuals would craft compelling arguments, meticulously written speeches for litigants to memorize and deliver. It was a high-stakes performance where every citizen, armed with their voice and perhaps a carefully composed script, wrestled directly with the weight of justice, their freedom, or their very life hanging in the balance. To maintain order and, perhaps more importantly, to ensure fairness and prevent endless, rambling orations, Athenian courts employed a remarkably simple yet ingenious device, the clepsydra, or water clock. This wasn't merely a timer. It was an unyielding, visible measure of a speaker's allotted time. As water slowly dripped from an upper vessel into a lower one, the sands of an orator's opportunity steadily ran out. Imagine the pressure. Every word had to count. Speakers would watch the clepsydra, their voices quickening as the water level dropped, knowing that once the vessel was empty, their time, and perhaps their last chance to convince the jury, was irrevocably gone. This ticking clock added an almost unbearable intensity to every plea, every accusation, every defense. Once all arguments were heard, and the clepsydra fell silent, the moment of judgment arrived. Voting in Athens was a remarkably sophisticated affair, designed to ensure secrecy and prevent coercion. Each of the 501 jurors received 2 bronze discs, one with a solid axle, signifying guilty, and another with a hollow axle, meaning not guilty. Jurors would then silently approach 2 large urns, one for the official vote, one for discard, and drop their chosen disc, concealing their selection with their thumb and forefinger. This ingenious method ensured a truly secret ballot, allowing citizens to cast their vote according to their conscience, free from the direct gaze or influence of their neighbors or powerful figures. It was a potent symbol of individual agency within the collective power of the dikasteria. With the votes cast and tallied, the verdict was delivered. And unlike our modern systems, which often allow for appeals and lengthy re-examinations, an Athenian jury's decision was instant and, perhaps most strikingly, absolutely final. There was no higher court, no supreme judicial review to overturn their collective will. Once the chief magistrate announced the outcome, the matter was settled. This immense power, vested in the hands of 501 ordinary citizens, underscored the radical nature of Athenian democracy. Their judgment, whether for acquittal or conviction, carried the unyielding weight of the entire city's authority. It was a moment of profound consequence, a raw demonstration of popular sovereignty, with life, liberty, or exile hanging by the thread of a simple majority vote. Should a defendant be found guilty, the trial often entered an extraordinary second phase, the penalty deliberation. Here, the power of the jury was once again put to the test. Both the prosecution and the defense, now facing a convicted individual, would propose a suitable penalty. The accuser might demand death, exile, or a heavy fine, while the defendant would counter with a lesser punishment, hoping to sway the jurors' empathy. After hearing both proposals, the 501 jurors would vote again, this time choosing which of the 2 suggested penalties to adopt. This unique process meant that even in conviction, the accused had one last opportunity to appeal to the jury's mercy, a nuanced layer of justice that revealed both the severity and occasional flexibility within Athens' formidable legal framework. Perhaps no event better encapsulates the raw power, the profound strengths, and the inherent flaws of this colossal judicial system than the trial of Socrates in 399 BCE. Accused of impiety and corrupting the youth, one of Athens' most renowned yet provocative citizen stood before the dikasteria. His unconventional defense, his refusal to beg for mercy, and his steadfast adherence to his philosophical principles challenged the very foundations of Athenian justice. The jury of 501, in a shocking display of their absolute authority, ultimately condemned him to death. Socrates' fate became a chilling testament to the power of the people, a stark reminder that while the system was designed for fairness, it was also susceptible to popular sentiment and political pressures, forever etching his name into the annals of judicial history as democracy's most poignant sacrifice. Despite the sheer, bewildering scale of their juries, ancient Athens' system offered profound strategic advantages. Perhaps most critically, it was an ironclad mechanism for accountability. Imagine a public official, knowing that their every decision, every expenditure, could be scrutinized not by a handful of appointed judges, but by a jury of 501 ordinary citizens. This constant, pervasive threat of euthanasia, the official audit and public review, served as a powerful deterrent against corruption and abuse of power. It ensured that judicial authority remained firmly, unequivocally, in the hands of the demos, the people themselves. This wasn't merely about justice. It was about safeguarding the very soul of their radical democracy, ensuring that no single individual or elite group could ever truly seize control, making every magistrate answerable directly to the collective will of their peers. But the dikasteria was far more than just a court of law. It was a living, breathing school for democracy itself. For any citizen selected to serve, jury duty was an immersive, unparalleled education. They were compelled to listen intently, dissect complex arguments, and weigh the nuances of justice, rhetoric, and governance. Day after day, they grappled with the intricacies of law, the art of persuasion, and the very foundations of their society. This constant engagement fostered an extraordinarily informed and active citizenry, deeply familiar with the principles and practicalities of their polis. It wasn't merely about rendering a verdict. It was about forging critical thinkers, shaping individuals who understood the immense responsibilities and delicate balance required to maintain a truly self-governing society. The jury box was their classroom, the trials their lessons. Yet, the very strength of such a massive, citizen-led jury harbored a dangerous vulnerability, the potential for the tyranny of the majority. When hundreds of ordinary men, often lacking formal legal training, deliberated on emotionally charged cases, the line between reasoned judgment and mob rule could blur alarmingly. Passionate rhetoric, appeals to sentiment, or collective prejudices could easily sway the decision, overriding logic and due process. The sheer weight of numbers, intended to ensure fairness, could paradoxically amplify popular sentiment, transforming a court of justice into an arena where the loudest voices or the most compelling emotions held sway. This was the darker side of direct democracy, a stark reminder that even the most well-intentioned system could fall prey to the unpredictable currents of human emotion and collective bias. This vulnerability to emotion inadvertently birthed another significant flaw: the rise of professional speechwriters, known as logographers, and highly skilled orators, the readers. While citizens were theoretically expected to present their own cases, the reality was starkly different. In a system where persuasive speaking was paramount, those who could afford the best logographers to craft their speeches, or the most eloquent readers to deliver them, gained an undeniable, often decisive, advantage. The ideal of an ordinary citizen arguing their case gave way to a competitive, rhetorical arms race. Justice, then, could sometimes become a commodity, disproportionately favoring the wealthy and well-connected who could pay for superior persuasion, effectively undermining the very democratic equality the system aimed to uphold. Furthermore, the very composition of these colossal juries, made up of ordinary citizens, presented inherent challenges. They were, by design, not legal experts. There were no professional judges to guide them on points of law, no trained lawyers to meticulously argue precedents. Decisions could therefore be inconsistent, prone to personal biases, or based on a shallow understanding of complex legal nuances. A juror might be swayed by a defendant's character or their previous public service, rather than strictly adhering to the letter of the law. This lack of specialized legal expertise, while intended to keep power decentralized, often resulted in a capricious justice system, where the outcome of a trial could sometimes feel like a roll of the dice, depending on the mood and disposition of hundreds of amateur adjudicators. The glorious, if flawed, period of Athenian direct democracy and its unprecedented large juries could not, however, last forever. The very forces that shaped its unique judicial system ultimately contributed to its slow, agonizing decline. Decades of devastating external wars, most notably the Peloponnesian War against Sparta, which raged from 431 to 404 BC, bled Athens of its resources, its citizens, and its confidence. Internal strife, political instability, and a growing weariness with the burdens of constant civic engagement began to erode the foundations. Ultimately, the rise of powerful external hegemonies, particularly the Macedonian Empire under Philip II and later Alexander the Great in the mid-4th century BCE, gradually extinguished the vibrant flame of Athenian self-governance, and with it, the era of the colossal citizen jury. Yet, even in its eventual demise, the Athenian experiment with citizen juries left an indelible, profound mark on the concept of justice. Despite its undeniable flaws, the potential for mob rule, the influence of rhetoric, the lack of legal expertise, it was a radical, audacious idea. Athens dared to place the power of judgment, the ultimate arbiter of truth and consequence, squarely in the hands of its ordinary citizens. This was a direct challenge to the notion of divine right or aristocratic privilege. It championed the revolutionary principle that collective wisdom, when properly channeled, could render fair judgment. This bold innovation profoundly influenced later philosophical thought on democracy, law, and the role of the individual in society, resonating across centuries and shaping the very foundations of modern legal systems. Centuries removed from the bustling Athenian dicasteria, the principles of citizen judgment persist, albeit in vastly different forms. Our modern jury systems, while typically comprising a mere 12 individuals rather than 501, are undeniably echoes of that ancient, colossal experiment. The fundamental idea remains that a group of one's peers, drawn from the ordinary citizenry, should stand as the arbiter of fact and law. This is the enduring legacy of Athens, the profound belief that justice is too important to be left solely to the elites, the experts, or the powerful. From the grand scale of 501 citizens in an ancient marketplace to the intimate deliberation room of today, the power of citizen justice, flawed yet essential, continues to shape the very fabric of our societies, a testament to Athens' daring and enduring vision. In our modern world, the ideal size of a jury remains a topic of fervent discussion, balancing efficiency with the pursuit of true justice. We routinely grapple with whether 6, 12, or even fewer voices can adequately represent a community or fairly decide a fate. Yet, in the bustling heart of ancient Athens, a radically different model flourished. Imagine not a dozen, but 501 citizens, drawn by lot, gathered to hear a single case. This wasn't an anomaly, it was the standard. The Athenian experience, with its colossal juries, offers an unparalleled historical data point in this ongoing debate about fairness, efficiency, and the very essence of representation. How could such an unwieldy number function? What did Athens hope to achieve by entrusting the power of life and death, fortune and ruin, to so many? Their answers challenge our contemporary notions, beckoning us to understand a civilization that took collective responsibility to an astonishing, unprecedented scale. This colossal Athenian jury system was not merely a judicial quirk. It was the very embodiment of the full, often arduous, burden and responsibility of direct self-governance. In the Athenian polis of the 5th and 4th centuries BCE, citizens weren't just voters, they were the government. From debating laws in the ecclesia, the assembly of all citizens, to administering justice in the dicasteria, active participation was not an optional extra, but a foundational pillar of their radical democracy. Every citizen was expected to be ready to serve, to listen for days, to weigh complex arguments, and to cast a final, consequential vote. It demanded an ongoing, active engagement that few modern societies could sustain. This wasn't democracy by proxy. It was democracy in action, highlighting a profound truth. True self-governance demands constant, vigilant, and often inconvenient participation from every single one of its citizens. Ultimately, Athens' 501 juror system was a breathtakingly bold, unprecedented experiment. Born from a fervent belief in collective wisdom and a profound distrust of concentrated power, it was a radical attempt to embed justice deeply, inextricably, within the democratic fabric itself. They sought to create a bulwark against tyranny and corruption, believing the sheer numbers would dilute the influence of individual bias or bribery. But like any grand experiment, it offered both soaring triumphs and stark cautionary tales. It proved the immense power of a united citizenry, yet also laid bare the vulnerabilities to demagoguery and the potential for collective passions to overshadow individual rights. As we journey deeper into the mechanics and philosophy behind this peculiar judicial practice, we'll unravel the ingenious solutions and unexpected challenges that made the Athenian court system one of history's most fascinating and enduring lessons in democracy's complexities. We've journeyed through the intricate workings of ancient Athens' colossal court juries, and what has become clear is this. The 501 juror system was far more than a historical anomaly. It was a deliberate, ingenious, and profoundly democratic response to the immense challenges of administering justice in a truly citizen-governed society. We've seen how this monumental jury was meticulously designed to prevent the insidious creep of corruption, to dilute individual and collective biases, and to serve as a constant, practical education in civic responsibility for thousands of Athenians. It was a formidable deterrent against demagogues seeking to manipulate the law, and above all, it stood as a living embodiment of the collective will of the demos, the people themselves. While imperfect in its execution and ultimately transient in the grand sweep of history, Athens' audacious experiment in popular justice continues to resonate across the millennia. It stands as a potent reminder of the profound responsibilities and the immense power inherent in a truly democratic system, where sovereignty resides not in an elite few, but in the hands of its citizens. It compels us to reflect on the eternal quest for fair, legitimate, and accessible justice, and the enduring, indispensable value of active citizen engagement in the governance of our societies. As we look at our own judicial systems, perhaps the most pressing question remains, what does the Athenian model, with its overwhelming chorus of voices, truly teach us about the ideal number of voices needed for true justice to prevail?